Enfish LLC v. Microsoft Corp. Enfish LLC v. Microsoft Corp. 822 F. 31327 Fed. Sir 2016 is a 2016 decision of the United States Court of Appeals for the Federal Circuit, in which the court, for the second time since the United States Supreme Court decision in Alice Corp. v. CLS Bank upheld. The Federal Circuit reversed the District Court's summary judgment ruling that all claims were patent ineligible abstract ideas under Alice. Instead, the claims were directed to a specific improvement to the way computers operate, embodied in the claimed self-referential table for a database, which the relevant prior art did not contain. Background: Enfish LLC and Microsoft Corp. develop and sell software database products. Enfish received U.S. patents 6,151,604 patent and 6,163,775 patent in late 2000, which both claim a logical model for a computer database. A logical model is a system for a computer database that explains how the various elements of information in the database are related to one another. Contrary to conventional logical models, Enfish's logical model includes all data entities in a single table, with column definitions provided by rows in that same table. The patents describe this as the self-referential property of the database. In a standard, conventional relational database, each entity, i.e., each type of thing that is modeled, is provided in a separate table. For instance, a relational model for a corporate file repository might include the following tables: document table, person table, and company table. The document table might contain information about stored documents, the person table might contain information about authors of the documents, and the company table might contain information about the companies that employ the persons. In contrast, Enfish's patents describe a table structure that allows the information that would normally appear in several different tables to be stored in a single table. The columns are defined by rows in the same table. Enfish's patents assert that the self-referential arrangement has several advantages: faster lookups, more efficient storage of data other than structured text, no requirement to model each thing in the database as a separate table, and thus the ability to be configured on the fly. A representative claim 17 of the 604 patent claims a data storage and retrieval system for a computer memory, comprising means for configuring said memory according to a logical table, said logical table including a plurality of logical rows, each said logical row including an object identification number OID to identify each said logical row, each said logical row corresponding to a record of information, a plurality of logical columns intersecting said plurality. Ruling of District Court. The District Court Failure, J. held that the fact that the patents claim a logical table demonstrated abstractness, since the term logical table refers to a logical data structure, as opposed to a physical data structure. Thus, the court's claim construction order had stated that a logical table has a data structure that is logical as opposed to physical, and therefore does not need to be stored contiguously in memory. Therefore, in essence, the claims capture the concept of organizing information using tabular formats. As such, the claims preempt a basic way of organizing information without regard to the physical data structure. There can be little argument that a patent on this concept, without more, would greatly impede progress. Given these observations, the court determines that the claims are addressed to the abstract purpose of storing, organizing, and retrieving memory in a logical table. This abstract purpose does not become tangible because it is necessarily limited to the technological environment of computers. When a claim recites a computer generically, the court should ignore this element in defining the claim's purpose. The court then proceeded to the second step of the Alice analysis, which is to determine whether the claims contain additional limitations that amount to an inventive concept. The court concluded the claims do not. Instead, The claims recite conventional elements. These elements, when viewed individually or in a combination, do not sufficiently cabin the claim's scope. Accordingly, the court granted summary judgment invalidating the patents. Ruling of Federal Circuit. Subsequent developments. In TLI Communications LLC v. AV Automotive LLC 5 days later, a different panel, including Judge Hughes, who authored the Enfish decision, and then TLI, invalidated software claims for failure to meet the Alice test. In TLI, the court held that a patent on a method and system for taking, transmitting, and organizing digital images was patent ineligible because it claims no more than the abstract idea of classifying and storing digital images in an organized manner. Several district courts have reacted to Enfish already in cases in which they had granted summary judgment. In Mobile Telecommunications Technologies v. BlackBerry Corp. In the Northern District of Texas, the court requested supplemental briefs on the Enfish decision. In Activision Publishing Inc. v. XTV Networks, Limited in the Central District of California, the court requested technology tutorials on the effect of Enfish. Commentary.